Good morning, everybody, and welcome to the Wednesday morning online breakfast seminar. Today we are joined by Mohammed Haque, who is consultant barrister, adjudicator and quantum expert at Silver Shemmings Ash, and he's going to be looking at construction case law updates for the last 12 months and the differences it will make to the way that we work and the way that contracts run. As always, if you have a question for Mo, he's happy to answer these. Please use the Q&A facility in the bottom toolbar. Pop your question in there, and then at the end of the presentation, I will answer as many questions as he can. Just to know if there's a question you wish to ask that you don't want to ask in an open forum, as you can see, Mo's contact details are on the screen there. He's always happy to answer emails that you send regarding specific issues. Mohammed Haque at silverllp.com. Okay, let's get started. Mo, over to you.
Thank you. Good morning, everybody. As Julie has already stated, this is about the case laws in the last 12 months. And construction law is a wide area to cover. It involves contract, it involves tort, and even sometimes judicial review and whatnot. So when I was asked to do that, I felt that because I'm a practicing adjudicator, and everything I practice relates to adjudication. So I will concentrate on this topic with the decisions that touches and concerns various aspects of adjudication, construction adjudication under the acts and occasionally under the contract as well. So that's the scope. That I'm not going to discuss anything other than adjudication, and you'll see I'll have to cover a lot even in the area. So let's start. And of course, this is kind of a bit of historical insolvency and adjudication. Okay, the journey started back in 2018, and the court held that at the TCC, the court held that a party in liquidation cannot adjudicate. So in other words, the question before the court at the High Court level, Technology and Construction Court, that can a company in liquidation start an adjudication under the construction contract it has with someone else? And the answer to that at the TCC was, no, you can't. No, you can't. You are, and the reason being that once the insolvency proceedings started, what happened? The administrator started compiling an account with every single debtor and creditor, and if it so happened that a creditor has some cross claims against the company in liquidation, then the view taken at TCC, you entered a different procedure. So your right to adjudicate under a construction contract at any time is lost, because you are then trying to balance the claims from the liquidating company to a creditor, and then the creditor's claim to you. So it's a balancing act, and whichever is a positive or negative balance starts at the end of that exercise, the amount will be paid by the liquidating company, or you will receive a payment. So that's a procedure already entered. So you cannot then start an adjudication, because the two would overlap. Now, the company that was in litigation actually appealed against the decision of the TCC, and the Court of Appeal decided that even in this situation, you can adjudicate. You can adjudicate, but what the Court of Appeal stated was that even though you can adjudicate, there won't be an injunction against it, but possibly because of this scenario of balancing accounts going on, you'll not probably be allowed to receive the money. Okay, so it'll be like, as a matter of course, that although you'll have an adjudication decision, the decision will not be enforced in the sense that you will not receive the money you won from the adjudication. So that was Court of Appeal. The Court of Appeal decision was also appealed to the UK Supreme Court, and in a very remarkable decision in 2020, UK Supreme Court has come to the conclusion that there isn't any bar for to adjudicate a claim for a party who's in liquidation. So no injunction will be granted at all against that, and also in the enforcement, there's no hard and fast rule that that will not be enforced. So a party will have the right to adjudicate, and his decision will be enforced. That party in liquidation will receive the money, unless the court decides on the facts and circumstances that there is a good reason for not to do so. So that's more or less Bresco saga, I would say. And I hope that almost all of you know this, but what we need to focus on today is my next slide. So there are 3 cases reported last year. In fact, 2 cases reported. One was unreported possibly because it was done in the county court. The enforcement of the adjudication decision was in the county court. But in any case, there are 2 other cases which were by the High Court, both by the TCC, and seen as application of the Bresco and Lonsdale principle. Now, Bresco and Lonsdale principle was first decided or applied to in Balfour. In Balfour, Civil Engineering v. Aztec Projects Limited. Now, in this case, interestingly, when this case was decided, the House of Lords, the UK Supreme Court decision was not there. So what they were doing was trying to fit in the Court of Appeal's decisions exception, meaning Court of Appeal said, yes, you can adjudicate, but normally we will not enforce it or not allow you to get the money, and unless an exception applies. So the claimant sought that this falls within the exceptions, the exceptional circumstances, and they referred to a case called Meadowside Building Developments Limited in liquidation with Hill Street Management of 2019. And the QC, Adam Constable, has laid down the principles on which it should be, governing, or how the judge will see if it fits in the exception or it fits into the general rule that it will not be an issue at all. It should be enforced. Now, the challenge was about some 3 contracts, 1 contract. We don't need to look at that, but the main idea was that the party has offered a security for cost payment of 750,000. So that's why that security of cost was needed. It was that the idea, the other side was saying that, look, if adjudication is an interim remedy, if in an ultimate Part 7 claim you fail, or you arbitrate sometime later, and if you fail, in that case, if you're already in liquidation, so in that case, if you don't have the money to pay back, where do we go, right? Where do we go? So the solutions that was tendered by the party in liquidation was simple. A, that administrator can ring fence the amount and keep it separate till such thing. Of course, you cannot just simply speculate. There has to be a clear evidence that you are litigating or arbitrating. But at the same time, if the adjudication, it becomes meaningless, because if the company liquidator has used it up, if you have a security, an insurance policy or something like that, that will be sufficient for the party going to litigation. So why bother not to? So even under the Court of Appeal era, where the general rule was you do not enforce it, rather, unless an exceptional situation occurs, the court found a way out that if you offer security, meaning the company in liquidation offers enough security, or if the liquidator ring-fence the money and confirms that he will not use it up, that's it. So it will be enforced. Now, interestingly, the second case I'm going to discuss, Tiles and Wood Limited in administration, the GECIF States, Trustees Limited. This is an unreported decision. This is an unreported decision because it was enforced by a county court in London, most probably, as far as I remember. And normally their decisions are not reported. However, having said that, it's you go on internet, you'll find it everywhere, because there are blogs written on it, and it's very well discussed over the internet. So it's not something that you all know. But again, this is after the Supreme Court's decision, where it was allowed that, yeah, you can adjudicate, no problem. And there isn't a rule that unless there is an exceptional, unless exceptional circumstances exist, you will not enforce it. No, there isn't any such rule there. But Riaz Hussain QC with the solicitors, they actually offered some kind of security anyway, because the Supreme Court decided that it's a matter for the court taking into consideration every fact and circumstances to come to a conclusion whether the decision should be enforced, or the enforcement should be held up till the balancing exercise of the insolvency proceedings come to an end with that particular party. So that's a question of fact, largely. So what Stiles and Woods lawyers did, they voluntarily offered some security, an insurance policy, and confirmation from the liquidator that he will ring fence it. And again, that succeeded. Interesting, that succeeded. So even though there is a change in the decision between the Court of Appeal and House of Lords, UK Supreme Court, what in practice happened is to avoid losing the enforcement rights. The company in liquidation will probably offer some securities, and of course it could be, or the alternative could be the liquidator, or in addition to the security provider, the liquidator could confirm that keeping the money ring fenced. So the last decision, that was John Doyle and Erith Construction Limited. That was slightly after the decision of Stiles and Wood in the same month, but John Dole was the first reported case, so to say, and the question again came that was the liquidator prepared to offer appropriate undertakings such as ring fencing the sum, and this was a final account dispute. And what the court did, it has set actually how it's gonna deal with this, in favor of a liquidating company. And interestingly, in the absence of proper security, that's why I said just earlier that it will be a good practice to offer some kind of security. So in the absence of a proper security or the liquidator's confirmation that you'll ring fence, the judge on the day thought that there is a risk if the money is paid into the company who is in liquidation, and then afterwards it spends it out. There's a real danger that when the final litigation outcome and arbitration outcome, if that says that, hang on a minute, you have done a summary proceedings in adjudication, but you're not entitled to the money, it was a wrong decision in one way or the other. If that is the case, then there's a real danger that the winning party in the litigation or arbitration was the losing party in the adjudication will not get the money back. And that's where the judge decided as a point of fact that he will not enforce the adjudication decision. Now, whilst even under the error of the Court of Appeal decision, TCC was happy, provided sufficient security was furnished, and the same happened after the UK Supreme Court decision in Stiles and Wood. So if we want to take a lesson from it, it's very simple, that we got to offer or ask our clients to be ready to provide security so that the judge on the day is convinced that if the party in liquidation loses the litigation or the arbitration, they will still the interest of the other side is well protected. So that's all about Bresco in 2020. Of course, it will be applied more and more, I'm sure, over the period of time, and we'll see what happens. Now, since we are in adjudication decisions, there would be challenges based on the fact that the adjudicator didn't have jurisdiction to decide the case. I mean, either because it was a question on threshold, for example, A and B, which was not on the list, or whatever other reason, the scheme didn't apply and they've gone for adjudication under the scheme, or the referral wasn't submitted within 7 days of the notice. So there are, or a breach of natural justice. So all sorts of jurisdictional challenges are seen. And there is a confirmation among these 9 decisions I'm going to decide. I'll go through them quickly so that we have enough time to discuss the other bits and pieces. I've summarized it under jurisdiction because in one way or the other, it's just a matter of convenience for me to do so. In one way or the other, the jurisdictional issue came up in these cases. And the first of these I'm going to discuss is FlexiDig Limited versus M&M Contractors Europe Limited. This was a challenge regarding an allegation of a breach of natural justice. Okay, this was also a challenge regarding the domicile of the parties and where the adjudication site or the site on which the parties were adjudicating were in England. But most importantly, I will discuss there is a part which is, and I'll focus on that more than the other issues here, is the jurisdiction of the adjudicator to decide under section 111 subsection 8. Now, what is that? I'll come in a minute, but let me just briefly state the other points. You know, in this contract, one of the parties were not residing in England. In other words, for example, I mean, it's quite common that there are contractors who are coming in here, doesn't have an office here or any presence in that sense through a limited company or anything, but the site is in England. And you know what? The adjudicator's jurisdiction is derived from a construction contract where the construction site is within England. So it doesn't matter that one of the parties were were not within England, but the contract said that, if there is an adjudication and enforcement, it will be enforced in Ireland, not in England. Despite that, and two adjudications already were there and they were enforced in Ireland, but despite that, the fourth adjudication this was, and this was a TCC application to enforce. And the issue arose as to the conflict of law, that why High Court of England, the context says somewhere else, but the court decided otherwise. They said, look, we have jurisdiction because the site is in England and the contract is a construction contract. It doesn't matter that two parties have agreed to enforce decisions elsewhere, that's your choice. But if one of the parties then come to us, we retain the jurisdiction to look into it and enforce it here. So it doesn't matter that you have agreed otherwise or the party is not in England. So if a question comes that, okay, I have a contract, the site is in England, but one of the parties, the contractor may be not in England, can I do an adjudication and go to the TCC to enforce it? The answer is yes. That's the first principle decided. And the second point is more important. That's fundamental. See, we know that the referral has to be submitted within 7 days of the date of notice. Okay, not date of notice, within 7 days of the notice of intention to adjudicate. Now, it was decided earlier that if there isn't any other provision, then the date written on the notice will be treated. So not the date on which it was posted, rather the date written on the notice itself will be treated as the date from which it will be counted. Okay, the 7 days period will be counted. So if I have a notice dated, let's say today is 31st of March, if I have a notice in my hand dated 31st of March, I do not put it into mail, in the Royal Mail, and assume that I didn't send an email either till 3rd of April, but my time will run from 31st March, not 3rd of April. But this one has been decided otherwise. It says that if the date starts counting from the date it's actually received or deemed to have been received. So it's immaterial that the notice was dated earlier. It's good enough if the notice, it could be proved by evidence that the notice reached the responding party, let's say 2 or 3 days later, then the time will start counting from that day. It's a very vital point. If you're in adjudication, you know how vital this could be. But I mean, be safe, always do that. Send it in an email and do it in 7 days of that day. But I'm saying in an unusual condition, if that happens, And if it's not been sent by email, if it's been sent by email, then the date of the email will start then counting. Or if by the post, then if there's a deeming provision, either under contract or express terms, that will apply. So that's the other thing. But the more important thing we have here is, or the most important, I haven't seen much of a discussion around that, which is about the payment notice. This adjudication, this case was, or adjudication was regarding the validity of a pay less notice, okay? And this was a smash and grab type, and there was a validity of the pay less or intention to pay less that the notified sum was in question. Very unusually, the pay less notice was for the sum of 0. Very unusually, the adjudicator decided that although the payment pay less notice was valid and he was not sitting on a valuation dispute, still he could correct some manifest error into the pay less notice, and he decided, let's say, a sum to be paid, not 0. So the pay less notice valid, he is not in a valuation dispute. Still, he decided, the adjudicator, that a payment would be made, whatever sum that was. Now, it came to the court, and unusually, the court enforced it. So it wasn't a breach of natural justice or the adjudicator going on its own frolic. That argument failed, surprisingly, but the handle the judge had taken, or the help the judge has taken, was from 111 sub 8, which says that if the dispute is about a payment notice under 110, in that case, the adjudicator has the right to decide that more or less payment will be made, even on a payment adjudication that has been interpreted as such. Now, that's about payment notice, 111, 8 and 9. That's not about pay less notice. So that was applicable only for notified sums, and the dispute has to be under 110 pairs of payee notice, sub 2 or A, sub 2 or sub 3. But the judge thought that we don't have to be extraordinarily legalistic, and we will enforce it, and the same principle will apply. So that's quite an extension for me, and unfortunately also I've not seen much of a discussion around it other than a couple of blogs here and there. So if you are somebody, take note of this aspect of the decision seriously. So go to the next decision, MW high-tech projects and Balfour Beatty. This is about crystallization of a dispute, and it's nothing new has been decided. More or less, if the parties knew what the dispute is all about, then even if there is a new report, an expert reports explaining what it was, is submitted very late, or even, we know that even if that has not been submitted earlier, the court will say that still dispute has been crystallized. So nothing new, but you can, you may read through to understand the facts of the case and what aspect has been decided. The next one is NG Fabricon, and again MW High-Tech, and this was decided that a plant construction was an excluded operation, rightly so, under 105.2. And so the adjudicator's decision will not be enforced because it was not a contractual adjudication claimed by the parties. Simple, it's under an EPC contract, and that was the decision the court reached. Very, very correct, I would say. So I don't know why this was not there at the adjudication level, or why this was not decided at the level of the adjudication, and then another case where conflict of law and jurisdiction arose. This time, Motorcas Construction v. Paolo Castelli SPA, where one of the parties was in Paris, and it was expressly written into this subcontract that the courts of Paris have the jurisdiction on the matter of any dispute. Yet the TCC found no problem in deciding that because the site was in England, because it was a construction contract, adjudication was a matter of rights in England, and this is an automatic right to the parties granted by the statutes and the CP civil procedure, that they can go to the Technology and Construction Court to enforce it. That's it. So it doesn't matter what the parties agreed expressly, that the adjudication decision will be enforced in this country. Nothing new, just a reputation. The next decision I have on jurisdiction is Aqua Leisure International Limited, the Benchmark Leisure Limited, where an interesting aspect was discussed again, and it is for some, it's a confirmation again, or should have been understood earlier, but not been understood. This is regarding the party cost, the lawyer's cost, the legal cost, whatever way you call it. Now, we know from the Housing Grants Constructions Regeneration Act 1996 as amended in 2009, that you are no parties to the adjudication are entitled to recover party costs, which includes, of course, the legal cost, at all, by way of damages or whatever the case may be, because 108 new provision says that you can only do so if you have a written agreement at the time of entering into the contract or after the adjudication has been started. Other than that, no, you don't stand a chance in such a situation to recover anything. Again, people are trying hard, and this time another futile attempt to recover party cost as damages under the Local Democracy, the Late Payment Act, cost of pursuing a debt. You know, the argument failed earlier. Fiona Farrell-J already stated that this is an adjudication, and the adjudication law says that you cannot do it other than that. So there is no scope for doing so, other than the fixed £100, which is not relevant here. Now, interestingly, the adjudicator actually awarded party costs under the in the adjudication, and the court said, no, the adjudicator didn't have jurisdiction, but it severed that part of the decision and said the main decision still is valid and the payment was directed. So severance is possible where it is clear, and also to remember that no right to recover party cost by way of damages under the Late Payment Act, because the Adjudication Act prevails, Section 108. Now, the next one I have is the Global Switch States and Sudlow Limited. And this is a case where the judge has excluded a defense because that was about valuation. Sorry, he's excluded a defense, and the decision of the adjudicator was not enforced on the ground of breach of natural justice. This has been a reaffirmation of Kentelon v. Uvesco, that the responding party has all the right to throw anything as a defense. If it is, let's say, if it's a money claim, so yeah, you cannot re-adjudicate till the if the decision is given unless you pay. But you can always give the valuation one as a defense. You can tender that, and if the adjudicator exclude that, the defense, then that because it's a smash and grab, I'm not going to look into the valuation. His decision will be null and void because of the breach of natural justice and will not be enforced. So but the problem is, I would just give you a note of caution. If you're an adjudication practitioner, there's something called approbation and reprobation. And of course, if a decision is taken on an issue of evidence or anything regarding evaluation, you may not be able to challenge it or present it differently in a subsequent adjudication. So remember that, and either put forward the defense or you avoid it. Very recently, I think last month, I've decided an adjudication where the responding party voluntarily decided to withdraw it. So that is something, of course, is a matter of concern for the responding party to think of. So Lane End Developments Construction with Kingston Civil Engineering Limited, where the referring party scheme was applicable, and the referring party has placed the request for nomination first and then served the notice of intention to adjudicate. And this is an unrectifiable mistake if this scheme applies. So order is very important. Under the scheme, it's written that you send the notice first, and then you apply for the nomination of the adjudicator. And if you miss that order, it cannot be waived. Well, of course, the parties can agree to proceed on a adjudication under a contract where, by agreement, they have to agree that the scheme will apply other than the provision I've just spoken about. That's the only way you can save it, but be safe than be sorry. Please do not miss the order of sending the documents. So the point of time is important here. Now, I've got two more decisions under jurisdiction. Usual, loads of things come in on jurisdiction. Roger Taha QC, sitting as a deputy High Court judge, was rejecting actually loads of arguments as a ground for not enforcing. However, one interesting thing, which is not interesting to me, but people thought it's interesting, was noted that the party who lost, responding party who lost, we actually paid the adjudicator's fee. And it was argued that because of that, the party lost the right to challenge the decision. Now, it was decided that no, if you pay the adjudicator's fee, I'm not talking about the money that was decided to be paid. I'm talking about only the fee of the adjudicator. Please take a note. And it was decided by the court, not unusually, that you can reserve your right to challenge and pay the adjudicator's fee. It's rather a good practice. So it's not a big deal that you paid the adjudicator's fee, but just because you did, you'd lose the right. But don't forget to reserve the right to challenge. That's important. The final decision on this list is Ex Novo Limited v. MSP Housing. And this is a consideration of an overlap between substance and jurisdiction. This is an issue. It arises very rarely. Let me just try to explain what it is. We know that the adjudicator doesn't have a jurisdiction to decide his own jurisdiction. He can only form a non-binding view, although it's a good practice for the adjudicator to form a view and express it as a preliminary point, so that, and if there is a challenge and it could be established that the adjudicator is right in forming his view, then the decision will be enforced. However, there are exceptional situations where the adjudicators do have a jurisdiction, and that is called the substance overlapping with the jurisdictional issue. So if the substance, for example, the claim were under actually 3 contracts or 1 contract, and one party said, for example, this was 1 contract because of so many things, and the other party said, no, this was not 1 contract. There were 3 contracts entered into by the same parties at different times. Okay, and this is a question which was the basis of their total claim, of course, because the final account dispute, the party claiming was under all 3 legs of the contract, as the adjudicator decided and the court found eventually. But at the same time, because there were 3 contracts argument, there was a jurisdictional argument as well, that unless the parties consents, you can't do it. But this was said to be a preliminary issue and separate on this case, but reaffirmed that it could be so that the jurisdiction and the substance, they overlap, and if they overlap, then the adjudicator has a right to decide his own jurisdiction because it overlaps. Now, I come to the enforcement scenario, and we have Broseley London case first, Broseley London with prime asset management. Now, when we have an adjudicator's decision, what we sometimes see is that the losing party representatives understand that there is little chance or at least chance to attempt to stop the enforcement. So what they do, they start fuller litigation or Part 7 claim, and then say, okay, we are not defending or challenging the enforcement proceedings, but please grant and stay of execution of that, so that once the other one is heard and decided, we will pay the net off or whatever, So that's a legitimate technique, but just to record that that this technique doesn't succeed quite often. As we call it always, pay first, argue later. Fair enough. If you have a case, go and fight it. When you win, you'll be seen. Okay. And it's not unless somebody is in liquidation or real danger. These are exceptional situations. Wimbledon Vago has decided them a long time ago. Unless there are something like serious evidence, it's highly unlikely. And that's exactly happened here as well in Broseley and Prime Assets Management. Interestingly, WRW Construction and Debt Developments Limited, I'm sorry, I couldn't pronounce it properly, or many of them, I'm sure, because I'm not good at pronunciation and I'm not native English either. So this is an interesting case where the merger doctrine has been rejected. What is this, a merger doctrine? Suppose you start a litigation, company number and company name is X, and then you are merged with company Y. So unless the new company, merged company, becomes the owner of your earlier contract and was a party to the litigation, you lose. You totally lose control of the cause of action. It dies because the earlier company doesn't exist anymore. It's like a death of a person, So that's a serious kind of a principle of company law, but this was used as a tool to defeat the award of a decision of an adjudicator. It was said that's not for adjudication. It doesn't matter that after the adjudication started, there was a merger and the in an ordinary litigation scenario, the cause of action would have been lost. It's an adjudication, and you can adjudicate it at any time, so even if after merger. So interesting. Come to the next slide. These are all payment adjudication related, and I hope we all know what I'm talking about. Payment adjudication. Sorry, I'm just searching for my notes, sorry. Okay, I have them. Now I've got 1, 2, 3, 4 cases. I'll run through them quickly. First one is Rochford Construction and Killan Construction Limited. This is again a reaffirmation of an age-old principle that if you have, this was decided actually in Hutton Construction, Wilson Properties as well, that if you have an express payment term, which is not scheme compliant, if it's a construction contract, then the scheme and the act would be applicable to supplement your express terms. So it will not be that the whole express term will go away, like the adjudication procedure 108. The scheme will only supplement your express agreement. So if it's lacking in one aspect or more than one aspect, and that's relevant for taking a decision, the scheme will supplement. So that's an old principle. It's nothing new in there, but you may read through the facts of the case to just see an example of that. Interesting. Q Holdings and Donald Associates Limited. Fiona O'Farrell J has decided, to grant a stay of a court proceedings. Decided to stay a court proceedings under a construction contract on the plea that there is a payment adjudication decision, a smash and grab, and the payment under the smash and grab has not been received yet. So the importance of pay first rule in smash and grab is so important that even if a litigation was in progress, and on the same subject matter, of course, and you by then get a smash and grab decision, the court will not say, okay, the litigation started earlier, so I'll continue, and you can stop and pay as whenever you like to, don't have to pay now. No, the court will not say so. Rather, Fiona O'Farrell J in Q Holdings and Donald Associates said, look, I'm not gonna proceed with the litigation. Doesn't matter when started. You first pay and then I'll look at it. So see how important, people think smash and grab is all gone, but no, how important that is, that you have a smash and grab and you really go ahead with this. Then the RGB plastering, Limited and Dry Lining and Plastering Limited. Again, a reaffirmation of an earlier case of Henny and Beck. This is about the validity of an application. If you have definition and requirements and conditions within your contract saying how the application should be, what are the dates and all this blah, blah, you have to comply it. If you fail to, then it becomes ambiguous that what date or what cycle of it relates to, and a non-compliant application is no application, so it will not be treated as a default notice. So that's something, nothing new, of course, been decided earlier, but just a reaffirmation of that principle. And the last one is JB Hopkins and Trent Engineering. This is again silly argument been tendered. This was an interim application number 26, which was adjudicated. That the only thing to take from this case is that contained mistakes. These were corrected in subsequent applications, and the parties were in application cycle number 33, but they adjudicated on that application a technical right to get the amount paid. And this was because this complied with the smash and grab rules. The decision was given in favor of the party claiming, and this was enforced. And the argument that by the 33rd cycle is something different been stated irrelevant for taking this 26th into consideration. You pay first and then argue later. So that's again, nothing new, sorry, but you can take a look. Stay of execution, or stay of the proceedings, I should have said, in the first case was Milchrist Developments and Waters. This is quite an old case on April 2nd regarding COVID, and an application was made with the plea that an injunction should be granted to stop the adjudication to proceed. But as probably we know by now, it was rejected, emphatically rejected, that because adjudications are really, just could really hinder, or the process is such that because it's done on email services and e-documents and all, COVID could really hinder the progress of adjudication. So COVID is no justification to get an injunction. The final decision I have here is JRT Development and TW Dixon Development. Sarah Watson J. Stay could be, this was not a party in insolvency or liquidation, but enforcement would be stopped if it could be established that the claiming party or the winning party has a real chance not being able to pay back if there is a litigation or arbitration, if that's decided. So of course you have a prima facie burden to establish that this is the case, and you have a good case to pursue. You have already pursuing the cases. But one note I would say post Bresco, that please try to organize some kind of security and make it a ground so that you don't lose the enforcement proceedings. And I think that's all. I mean, from my end, I've done maybe 5-6 minutes more than normal. If people have questions, please.
Okay, it looks, Mohammed, like no one has a question this morning for you. That's good. You've obviously made such a fantastic job of explaining it that it's clear. And
I couldn't understand anything out of it.
well, I'm sure it's a former rather than the latter. As always, if you have a specific, please.
Well, I mean, I see, Julie, a couple of people have raised their hands. I don't know if, or chat. No, there are chats there.
Okay, I've got hands raised, but I haven't got any questions. So if those people...
No, okay, yeah, no. It's somebody's...
Yeah, sometimes that happens by accident. So
no.
There's definitely no questions on that.
Steps are about thanking each other. Okay, yeah, that's it.
Remains to say thank you to Mohammed for his time this morning and the explanation of the case law updates from the last 12 months. As always, if you wish to contact Mohammed directly about a specific issue, it's Mohammed Haque, HAQUE, @silverllp.com. Next week, which will be our first one for April, we have Conor Ahern with the latest in his QS series, and he will be talking about payment security. Now, if you'd like to book a place on that, please email me at seminars@silverllp.com. And the newsletter will be out shortly as well, detailing all of April's events that we have coming up. If there's, anything specific, please drop us an email. Otherwise, have a great day, everyone. Looking forward to the bank holiday weekend. And thank you again, Mohammed, for your time.
You're welcome, Julie. Thank you. Have a nice day. Thank you. Bye-bye.
See you all soon. Take care.
Bye-bye.